And I'll get started as soon as you give me the word.
Also, secretary, my old secretary.
All right, we are live.
Okay. The chair calls to order the May 22nd meeting of the Kansas Governmental Ethics Commission. Welcome, commissioners and staff. Thank you for your attendance today. In your materials, you have today's agenda and you have the minutes from our meeting on April 24th. Can anyone identify any corrections that need to be made to the agenda or the minutes as written?
We might want to take out the word in that first paragraph, the word with before Mr. Jackson, and just put Mr. Jackson was not present in parentheses.
Noted.
Okay.
Are there any additional corrections that need to be made?
Does that make sense, Chris?
Yeah, it does. It's just, I carried that format throughout, the rest of the minutes too. So if we're gonna do it there, we might as well just do it throughout the rest of it.
Well, I don't think you read the word with any other place in the minutes.
Yes, I do.
You do?
Yeah, it's on page 3.
Okay, well, you might want to make that correction as well.
Okay.
Okay. Anything else that anyone identifies? If
Just-
there are
just
none,
for
I'll
clar-
take-
Just
The
for
word
clarification,
with is-
I don't have it in front of me. Was that previous comment because I joined a couple minutes late? Is that why we're talking about, there was a statement about
Yes.
the last meeting, whether or
Yes.
not, okay, I see Paige
It's
nodding.
Yeah, it was just the approval for the minutes of the prior meeting. I think you were just on maybe a minute or two after.
Okay.
Yep.
It's not the word with that is
Fair
a
enough.
problem. It's the word, it's the parenthetical phrase. It's a problem with the word yes.
Yeah.
Okay.
Word with. is
Anything
fine.
else?
I don't know.
If not, I'll take a motion to approve as amended.
So moved.
Come on.
Motion has been made and seconded. Is there any additional discussion? Hearing none, all in favor of approving the motion to approve as amended signify by saying aye.
Aye.
All opposed say nay. The motion passes. Turning to the agenda, we'll begin with an introduction of a new commissioner. Director Scovelin, do you want to start this topic?
Sure. We actually have a new commissioner, Mr. Ramirez, and we also have a new conflict counsel, Mr. Burris. So I figure we can very quickly do just a quick round, let people introduce themselves. I can start. Mark Scovelin, I've been the director since 2017. I know both of you already know me, but just as a reminder, I've been here a little while. I'm an attorney as well.
John Solbach, I been on the commission for 20 years or so. I'm the minority leader in the Senate is my appointing authority. I served in the House for 14 years, chaired the Judiciary Committee the last 2 years. Before I came back to college, I served 3 years in the Marines, moving 13 months in Vietnam. I wrote about it in that chapter. I'll be telling you that. And I'm from Lawrence. I'm an attorney. Today is my 50th wedding anniversary.
Congrats.
Congrats.
And we're married. We have 2 children. One lives in Shawnee County, one lives in Douglas County.
Paige Quintana Paget. I go by only the first name, first last name, and office manager here since, I've been with the commission since 2022.
I'm Tess Ramirez. I'm also an attorney, but I work remotely, so it's great. I graduated Washburn Law School, but I have my bachelor's and my MBA through Baker. And I have 3 kids, 2 biological and a foster that we're working on adopting.
Hi, my name is Earl Glenn. I was the most recent member of the Board of Appointments by Chris Kobach in March. I've been retired for 2 years. I did research work before that, primarily in medicine and health sciences. And I'm from Olathe right now, but I was from about 100 miles or 50 miles west of here originally.
I'm Jesse Burris. I'm with the AG's office, LVV, new conflict counsel. Jay and I are basically switching places, I guess. That's one way to put it. I'm currently in the special litigation division. have been since January 2023. I'll be moving to Logic, I believe, formally as of tomorrow.
Nice.
So it's great to meet everybody.
Where did you go to law school?
Washburn.
Okay. One of the two best law schools in the state.
Yes, sir.
Jay Rodriguez, been the acting conflict counsel for about 6 months now, 8 months.
Yeah. what
Uh,
a-
And I'm Assistant Attorney General. As Jesse said, I'll be moving over to the Special Litigation Division of the AG's office. And Jesse taking over for me. I guess formally starting next meeting. There's any confusion about that, but yeah, it's been great working with everyone in the commission, Mark and Caitlin, everyone, been great. So I've really enjoyed the time here.
Yeah, congratulations to both of you for making moves.
Hi, I'm Chris. I'm an attorney as well. I'm Lawrence, do construction and eminent domain.
Not to break the chain. I'm from Salina, I'm attorney and in relation retired district judge. And really excited about your opportunity because ours went backwards. We adopted our first child. And then once I had a pattern, I figured that we had 2 years of great time, welcome aboard.
So I'm Caitlin Bull Stewart. I'm the general counsel. I have been general counsel for almost a year in June. And prior to serving as general counsel for the commission, I was in private practice at Reardon Fincher and Mayo doing commercial litigation, general business law, probate, a lot of civil, everything civil except for family law for the most part. And it's been a great time here. It's excellent learning opportunities. And just an exciting time, especially with elections coming up, to be able to be on a commission that makes a difference. So welcome.
Andrew?
Hi, I'm Andrew. I'm from Prairie Village, Kansas. I went to K-State for my undergrad, and I'm currently a law student at KU. And in August, I'll be a 2L. So,
And Bo?
Yeah, welcome to the new folks. Bo Jackson, I'm a partner at Hush Blackwell in Kansas City. Practice international IP litigation for the most part, originally from Andover and now live in Fairway.
And for myself, I'm Nick Hale. I'm originally from Wichita and currently live also in Fairway. I'm a in-house corporate counsel for alcohol manufacturer in the Kansas City area. And I've been on the commission now for 5 years as the chairman. And you know, we've seen a number of new faces come through here, and it's always a joy to get to meet somebody new. So welcome to those of you that are new to the commission. I look forward to working with you.
Great.
All right, and with that, we also have the next item on the agenda are some advisory opinions. Caitlin, do you want to speak to these?
Yes, absolutely. So the first advisory opinion is the one that we've been working on together. And that is advisory opinion 2024-01. The changes I made were in response to the last meeting. We've drastically simplified down the factual statement, the analysis, to make the focus of the opinion about the candidates or the party committees, really getting the identity of the donor as being the key focus of the opinion. And so we've had a lot of discussion for this before, but briefly for those of you that are new, we received an advisory opinion request because candidates, and not necessarily party committees yet, but candidates were receiving contributions from that it was processed by a third party. So the contribution checks did not immediately identify the donor of the funds. Instead, there were additional steps that had to be taken. And so the conclusion of the opinion is that candidates or party committees can only accept those contributions if they are able to identify the donor of the funds to comply with the campaign finance statutes. Did anyone have questions?
I do have one additional comment.
Yeah, absolutely.
I do want to highlight as well in the last paragraph, the last meeting, I think the big issue that was causing some heartache for the commission in the opinion was that it wanted to be very clear that this opinion in no way addresses or accepts or addresses the legality of the payment processor's other activity or anything else that it does. It's very focused on the questions that were asked. And so that last paragraph is very specific to essentially say, we are only talking about the question that was asked, we're not generally accepting anything that this payment processor does. And in fact, I don't think the payment processor is mentioned in the analysis anymore.
No, yeah, because we'd moved away from making it overly specific, and thank you for reminding me of that. That was the request, was having a general disclaimer at the end of the opinion to be clear that we are only speaking to the legality of what the candidates and the party committees may and may not accept.
Thanks, Brad.
Yeah, absolutely.
I have a question.
Yeah.
And I guess it's on the second page. So the paragraph starts KSA 2541. It says no person shall give or accept any contribution in excess of $10. Is that per that cycle that you're in, that $10, or is that per a donation?
That is per donation. There is also a separate part of that prohibition that sets an aggregate anonymous contribution limit at half of what one contributor can give. So if a candidate can accept $500 in an election, one donation is limited to $10 of anonymous contributions. But across that cycle, across the primary cycle, they can accept up to $250 of anonymous contributions.
Because one of the problems with these electronic things is multiple very small dollars.
Yes.
And actually thousands of very small. So they could in theory give $9 enough times to get 250, then they'd have to be reported, you're saying?
Yes, and if theoretically, if one person gave $9 in one instance and then gave $9 again, then they are no longer under the anonymous limit anyway.
But
so they should be disclosed at that point.
But each of those 9 could be anonymous.
Yes.
So they could have 20 different contributions that are anonymous. And then only once they hit the 250, then how would that be listed? Because they never gave it to $250.
They would have to return anything over that amount, or dispose of it in a usually to a charity.
No, I guess once they go over that limit, they can say they're giving $9 and they're going over the $250 limit. Where is that on their report then? They have to report all those?
Yes.
They don't have to report any of them until they go over the 250 and then they have to report all of them. Is that?
Yes, that's correct. Now, one person is limited to giving $10 anonymously, but again, this is something that's very difficult to police because, like you said, one person could give $9.99 repeatedly anonymously, and the candidate realistically would not know. But that's why it's important to have those anonymous aggregate limits that prevent it from reaching over $250.
It's $10, isn't it?
Yes, for one.
Well, I'm just using 9 to keep under the 10.
I know.
But yes, you're correct. It is $10 for one instance, and then half of what one donor could give in the aggregate over the election period. That's correct.
Okay.
And in the context of this opinion, the reason why we don't state only if it's checks for $10 is that there are concerns of how the processor is sending out checks, and I don't want there to be any chance that a contribution, it appears to be under $10, but they broke up the check in some weird way. So we're just erring on the side of being cautious by getting the identity of the donor.
Yeah, reflecting the comments from the last meeting, I think it's now very focused on just what does a candidate need to do in order to be able to legally accept these funds, or when do they have to send them back?
And I have another question, or in the second and last paragraphs, they have legislative session in the second to last paragraph, and then they have regular legislative session in the very last paragraph. What happens in the special session they're going to have this summer? How's that is that a legislative session?
Yes.
But that doesn't, the regular legislative session, that wouldn't be a regular, so.
Let me look
The
at,
question was asked in the context of the regular
Yes.
session, but it's an easy change. The way the statute.
We just need to have a vote.
this is a
Yes.
quote from this is the statute that's quoted.
Right.
It's the statute is worded oddly.
Yes.
Because,
The-
sorry, go ahead.
You're fine. The statute says that you can't accept a contribution from a business, PAC, lobbyist, etc., after January 1st until sine die of the regular session. And when a special session is called, it's not when it's called, it's when it convenes
Right.
until it adjourns.
But that is covered.
And
It didn't seem to be covered here, but
that's
it is
correct.
covered.
Yes, it's not, it is part, the analysis of what underlie that as well, but typically the analysis again was focusing on the very question of essentially when you identify the donor, if it's legal to accept, you can accept it. But the issue is you can't just accept it without knowing who it is, essentially.
Mhm. And the latter half, this is why the statute, I think, is written a little confusing because it says prior to adjournment, sine die of the regular session of the legislature or at any other time in which the legislature is in session.
Okay,
So that's why it's worded that way. you know, who knows, but that's why it caused a little bit of confusion. But again, as Mark said, they were asking within the regular session. But we can just take out the word regular when we're not quoting the statute,
Yeah, just to,
to be clear.
yeah,
Yeah.
that's what I was, that's.
Yeah, I will definitely make that change, so long as that's included in the motion.
Sure. Any other questions, comments?
Commissioner Solbach.
I would move that we adopt the opinion with that change.
Do I have a second?
I second.
Thank you, Andrew. Any additional discussion about this particular wording? If not, we'll take a motion or we'll take a vote. All in favor of approving the motion to approve the opinion as amended, signify by saying aye.
Aye.
All opposed say nay. The motion passes. The next item on the agenda is an executive director's report. Director Skoglund.
We actually have a second opinion first, if I would defer to Caitlin if that's all right.
Oh, sure.
Yeah, so this second opinion, we did receive the request within the deadline as required by statute, but as I started to work on the draft for the second advisory opinion request, and all we have in the materials is the request itself. I'm still working on the draft. It's a little bit more complex, so I would just ask the commission to give me an extension of time until the June meeting to present the draft of that opinion. If anyone would be willing to make that motion.
That's so moved. Second.
Motion has been made and seconded. Any additional discussion on the motion to extend time until the next meeting with respect to this opinion? Hearing none, all in favor of approving the motion signify by saying aye.
Aye.
All opposed say nay. The motion passes. Now we have the executive director's report.
Okay, before we get into the activity reports that I'll be talking about, I do want to have one quick housekeeping comment in the executive director's report. You might notice now that we have a lot of people who came physically to this meeting today, which we always appreciate when possible, obviously. However, that also means that we are printing a lot of material for recessed session in particular right now. We're going to start requesting honestly, at this point, it's almost a budget savings as much as it is a savings of staff time. That if you are able to bring a laptop, we can provide the materials electronically. If you would still prefer paper, we will obviously provide them on paper. But anyone who is okay with looking at the documents on a laptop, that will be the default assumption, is that you will bring a laptop and we will provide the documents electronically.
So opt into paper.
Yes. Yeah, because they're.
I'm gonna need paper.
That's entirely fine. I think there's a section of the Amazon rainforest that is unhappy with us today. So, but we're happy to provide paper or do anything to support the commission, but we are going to switch to that default mode. So anyone who wants paper, when we send out the notice to ask essentially if you're coming and if so, how, we will also include, if you would like paper, please ask. Otherwise, we will assume you will bring a laptop.
I will plant an extra tree every month.
We have a standing order for the commissioner.
But most of those materials will be available the day before anyway. Right?
Yes, it's the same materials that are in
Okay, because that's very convenient the day before.
Yes, it's the same materials that are in the confidential shared folder.
Okay.
So you have access to them before the meeting. Okay, first, to dive into the actual reports, statements of substantial interest. We know all of you have filed your SSIs. Thank you for doing that. They were due at the end of April. We have a update as of today. 6,235 people had to file an SSI in Kansas, and only 311 are outstanding as of today. I think that's a little bit of an update from the document that you have. We had a lot come in over the last day or two. This includes every elected official has filed their SSI, which we very much appreciate. Those are the ones that a lot of times the public is very interested in looking for. Most of the ones that are left over are from, usually there's a few 8 large state agencies. Like, for example, right now we have 92 outstanding from KU Med, 67 from Wichita State. So it's usually there's big issues with just a lot of employees that need to file. Yeah. But that's still, there's only 5%, less than 5% that are still outstanding, which is great. You'll notice we don't typically assess a lot of civil penalties for SSIs. You'll notice today we're not assessing any. That's pretty normal. We try to give a fair bit of forgiveness on these because a lot of people are sometimes first-time designees in an agency. Sometimes they were never notified that they were a designee by their agency. So there's a lot of things that we work through to try to help people. The second is the May lobbyist report. The deadline was May 10th, and I'm going to hopefully start providing these more regularly on our lobbyist deadlines. There were 1,107 reports that were due, and 2 of those had failure files that were sent. And of those, both of them actually filed the day we put that in the mail. So we have 0 civil penalties for lobbyists. That is a 99.82% compliance rate for failure to files and 100% for lobbyists. I'm gonna have to give Jessica White a shout out for doing such a great job working with our excellent lobbyist team in Kansas. So, but yeah, 100% compliance. Can't ask for better than that. Any questions about either SSI or lobbying compliance updates? If not, that's all I've got.
All right. Thank you, Mark. The next item on the agenda are some civil penalty assessments to note. Do you want to speak to those?
Sure, there's just 2. The January 2024 report, the same person had 2 open accounts. That report was not filed. They were assessed the maximum.
I have a question.
Yes.
I seem to find that guy that his first report was due in January of 2021. So why are we just hitting that now?
This is the January 2024 report that he is being assessed for.
Oh, but
Anytime someone has an open account, they have to file on every January 10th.
But why don't they become like a dormant account once his election was a long time ago?
It was. There are people who leave their accounts open for a very long time. In fact, the commission actually made a recommendation in the last annual report to require closure of campaign accounts that were open for some time. There are some accounts that have been open for in excess of 25 years.
And they file every period?
They often do. They file every January 10th.
But some of those aren't online anymore because some of them.
That's correct. Most of them are not online anymore.
But you have to go through all those anyway then?
We do process them and we do make them available if they, to the public as well. So anyone can ask for those anytime. They're things that anyone can access. Typically, when someone is no longer an active candidate, those reports are things that the public is not actually looking for. Our website focuses usually on people who are active candidates.
Yeah, because this guy's not a candidate rolling.
Right. It's a carryover candidate. It's someone who had an open account and never closed it. And right now, there's nothing in Kansas law that requires closure of campaign accounts.
But you can't administratively give it like a dormant status that once they lose an election bad, they typically.
We do occasionally, in some very, very, very rare instances, we have administratively closed accounts. Typically, this happens when the only money that was in the account was something they had loaned to themselves. So if there was anything left, they could have just given it back to themselves. It's unclear whether they actually had a campaign account at all. Anything like that where there's not the staff deems that there's not a transparency detriment, we send a notice to them essentially saying, we will administratively terminate your account if you don't respond to this or file something in the next 30 days. They don't, and it gets administratively terminated. This doesn't happen very often. It's only in very rare instances.
Because these fees will take about half the guy's balance that he has in those 2 accounts.
Right, but there is a balance, which is the issue.
Yeah.
So.
Great questions. Any other comments, questions?
I very much appreciate the discussion as well, because I think that this kind of interaction is very helpful to see kind of what staff does as well on a day-to-day. So please, if you all have questions, please continue to ask them.
Well, I think some of this we need to give feedback to the legislature that
Yes.
these accounts need to be administratively closed, if not really closed.
I absolutely
And if
love
they're a
that.
dormant candidate, we shouldn't hammer them so hard, I guess.
Yes.
So
Yeah.
did nothing come of that 2-day extravaganza last October?
Not yet, though I know there's things in the works for next year. We're hoping to be on the forefront of that rather than left out of the table, but we'll see what happens. We generally support good changes being made to the law. We know we've had some conversations in here about that. I'm sure we're going to workshop quite a bit, and I'm looking forward to our conversations about our regulatory overhaul as well, which now that we have some great advice from the Attorney General's office on how to handle those.
Oh, wait, that didn't come out right.
So he's like, that was not me. Like, I'm not in that division, so.
So we appreciate that, and we're hoping to move forward with some of those subcommittees going forward. We're really excited for that as well.
Yeah.
And that'll help with statutory analysis.
The next item on the agenda is there's a civil penalty waiver request.
Yes, this is, there's only one today. This is for a central committee chair. The report was due in January 2024, was received at the end of March. Was to set the maximum $300 penalty. He asserts a medical circumstances category of good cause. You have the analysis there, or his additional explanation that he provides. You have at the bottom of that back of the sheet, you will notice he also did not provide any supplemental documentation. I do not recommend waiver of the penalty. The previous treasurer for the central committee had properly resigned over a year prior to this deadline. We actually notified Mr. Harden that as chair, he was legally responsible for reports until a new treasurer is appointed. They did not appoint a new treasurer. Legally, he is the only one liable for the reports, so it's unclear why a medical claim about someone else who is not liable for the reports could support a category for good cause. So I would encourage denying the waiver.
I have comments about this one. I looked at this guy's reports, and for over cycle, he reported $48.48 in cash.
Yes.
No money coming in, no money coming out. And the one he filed after this was all over said the same thing. So there's like, and this is in a small county of 2,000 people, way down in south of Dodge City.
We always encourage people to terminate their accounts if they are unable to file their reports.
But I guess the fine seems almost abusive given the financial nature of.
They have a 15-day grace period after we send the failure to file, and then it goes up $10 a day up until they hit the maximum, which is $300.
And it's calculated by statute automatically. It's not a determination the commission is making.
Earl, as a member of the commission, you have the ability to make a motion.
I would like to make I don't like to waive the whole thing. I think there should be some penalty. I would move that we only assess this guy $20.
It would be, I just want to make a comment. I don't disagree with your analysis in any way. I will just make the point that the commission, I think, did very good work on the guidance document. I do not think this constitutes a medical circumstances waiver.
I'm making that regardless of that.
I understand. I understand.
The medical waiver wasn't there, just the circumstances of.
I am just very.
I'm just trying to take a reasonable person's look at this. What was the thing we had last week from the attorney? But a reasonable person looking at this said that fine doesn't fit what happened.
To be fair, though, the guidance document that was put into place is binding on the commission, and the guidance document only considers categories of good cause as they are listed on the form. So the only way, so the medical circumstances of a person essential to filing or their immediate family member, if he was the only person who is essential to filing and he does not assert a medical circumstance of himself. So if the commission were to vary from the guidance document, there needs to be a very thorough discussion to be included in the minutes, because we need to very clearly say why we're going away.
So the
from that.
guidance document only really allows for that medical exception, which doesn't seem to exist.
It's
Earl, why don't you recast your motion that regardless of the guidance document, for other reasons,
Regardless of the guidance document, for the reasons I think we should waive this.
It's my concern that that may be out of order without an explanation for why because there needs to be an
The
explanation.
explanation is there's no money coming in, no money coming out.
Yes, that's what we needed.
It's been, well, they've had this same report for at least four reporting periods, and then it was the same after he did turn it in. So there was no harm, there's really no harm to the public by the failure in this case.
That was the explanation we wanted
Okay.
for the record.
So that's attached to the motion, just for clarity, the explanation.
So harm to the public, I guess, is what I'm looking for here, or how did the public, how was the public harmed by this?
Do any other commissioners have comments?
what you say makes sense. I'll second the motion.
Motion has been made. The motion has been seconded. Is there any other comments or questions from commissioners?
Quick question. I think the motion makes sense as well, but just to help me understand, Mr. Glenn is proposing to reduce it to $20, and what would it be otherwise?
300.
Thank you.
I just don't think we should take all the penalty off, because there was a violation, there was a technical violation here, so I'm against zero, but some modest amount that.
I'll just say, from my perspective, this form that we came to evolved over discussions in an attempt to get away from some of the arbitrary natures you know, in the ways that we would decide to forgive a fine. So I find it interesting. And Commissioner Glenn, you're obviously a new and valued voice on the commission. But part of the reason this forum is now in existence was to try to create more guidelines based on the rules that we're given to either accept or reject a request for a civil penalty waiver. Commissioner Berger, what are your thoughts about the desire to deviate from the form as we've put it together?
I think we're always free to abandon whatever we've done in the past, but by doing so, we do step right back into the arbitrary and capricious side of things. And there needs to be some sort of guidance so that people know what they can and can't apply for. And if it's true for this individual, the legislature set this up in a particular manner, which we may or may not agree with. It allows us to make a particular waiver under certain circumstances, which we've outlined, I think is appropriate.
Does the guidance factor in the population this is a county of 2,000 people that were affected. So why is that person fined the same as the whole, somebody with a multi-million-dollar campaign at the state that has a staff to do it? So that's what I'm having a problem with.
Statute does not take into account population, and the statute is what calculates the amount. The guidance document is the guidance document is not about the amount that's penalized. It's only about our discretion to waive.
The statute doesn't, the statute gives us the power to modify. We've tried to tie our own hands with this document, but what Mr. Glenn's research has shown and the point that he makes sense in this particular case. And so.
We are authorized to, under unique circumstances, and I'm struggling what's so unique about this. I hear your argument, but there's nothing unique about the fact that somebody's keeping an account open for reasons unknown, $45, and this could have been easily solved by their own action. Here we are. Are we enabling somebody to continue to just not do what they ought to do? Or are we actually saying, okay, yeah, this is, I don't find the uniqueness. I hear your argument, but going to the finding of fact to find back on the bench, I'm struggling with finding the fact. And that's why being on the commission prior to all these changes, we went down that rabbit hole many times, and it certainly became in the eye of the beholder.
Yeah.
And we wanted to get away from the eye of the beholder, so I think.
But I think population and the amount of money involved should be a factor, and I don't see that as being considered right now.
What's unique about it?
That you're treating somebody with a very small amount of money, $50, the same as you're treating somebody with a multi-million-dollar account.
They're asked to do the same thing.
There's nothing unusual. The error rate in the $1 million account is probably higher than what this guy's being fined and his.
I don't disagree with that, but it's the same obligation for everyone.
All right. I made my case.
Well, the motion has been seconded, so we can take a vote on it. I guess if we don't mind, I'll just do a roll call vote. Commissioner Helmer, do you vote to approve
No.
yay or nay?
Nay.
Commissioner Solbach?
Yes.
Commissioner Dangler is absent today. Commissioner Berger?
Nay.
Commissioner Harrison?
No, but I hear Mr. Glenn's arguments, and maybe we could take that into account for future events.
Mr. Chairman, I think Commissioner Ramirez replaced Commissioner Dingler.
Yes.
Oh, I thought it was Commissioner Schonifer's seat. Sorry. Commissioner Ramirez, yay or nay?
Nay.
And so Harrison, you were a nay vote?
Correct.
And Commissioner Jackson?
Yay.
Okay, so we have 3 yays, so the nays have it. Do any commissioners wish to make an alternative motion? If there are none, then the civil penalty just remains in effect. Is that correct, Director Skoglund?
That's correct.
There are no alternate motions. We will proceed. Returning back to the agenda, we have civil fine hearings, complaints 761, 766, and 767.
You said three yes for this.
Do we have any of the respondents in attendance today?
I'll go to that.
Hey, just checking to see if the respondent is in attendance.
No, we don't, Mr. Chairman.
Okay. And so Commissioner Berger has agreed to be the presiding officer in the hearings today. Commissioner Berger, are you prepared to conduct the civil fine hearings?
Yes, Mr. Chair.
All right, well, I turn it over to you.
Thank you. Thank you. So I'm Chris Berger, Commissioner Berger, and I've been appointed as the presiding officer in this matter. And we've actually 3 different matters before us. There's Mr. George Briggs, number 761, Sam Stillwell, 766, and Daniel Stillwell, 767. I will call each individual hearing to order separately, but with a little bit of overlap up front, just perhaps for the expediency and the default setting of how this appears. As to each matter, please enter your appearance.
Caitlin Bull Stewart on behalf of the complainant, Mark Skoglund, the executive director, in complaints 761, 766, and 767.
Does Mark Skoglund also appear?
Mark Skoglund also appears
As witness.
as a witness.
Now, and just for our kind of localized record of things, in this particular room is Mr. Briggs or either of the Stillwells present. If you are, please announce yourself. Hearing nothing, you've gone down the hallway and not been able to identify those individuals being present.
Correct.
And could you please give us a quick proffer as to the jurisdictional setting of this?
Absolutely. I will keep everything as succinct as we can. As you've all had our proposed, the executive director's proposed report and order in front of you for a couple of weeks. Regarding jurisdiction, Mr. Briggs subjected himself to the subject matter jurisdiction of the commission by filing his candidate's declaration of intention form, thus subjecting himself to the Campaign Finance Act. He's also a resident of the state of Kansas, thus there are no personal jurisdiction issues here.
That's for Mr. Briggs.
Yes, that's for Mr. Briggs.
Is it true for each of these?
That is true for, I apologize, I didn't realize that's what we were doing.
I didn't make it clear.
For Sam Stillwell, he also was a candidate under the Campaign Finance Act and consented to subject matter jurisdiction by filling out his candidate declaration of intent form, also a resident of the state of Kansas. Daniel Stillwell was appointed as treasurer by Sam Stillwell, also subjecting himself to the subject matter jurisdiction of the commission through the Campaign Finance Act. And Daniel Stillwell is also a resident of the state of Kansas.
So these are matters for a complaint hearing before the Kansas Governmental Ethics Commission. These hearings will be held and conducted according to the provisions of the Kansas Administrative Procedure Act. The applicable burden of proof is that affirmative findings of fact by the commission shall be based on clear and convincing evidence. Back to our procedure of things, this hearing is being recorded. Therefore, responses to questions must be verbal, as the audio video recorder does not pick up on nods, unclear responses, and other gestures. We will allow the complainant to provide an opening statement. The respondents, none of them are present, and therefore they have no comment to make. The complainant will then present evidence subject to any examination that we may wish to give as to it. And in fact, we have the authority within ourselves to enter a default judgment based on non-appearance with a sworn proffer of facts, and then the preparation of a journal entry in that regard. And I guess I want to ask everybody, what level of formality would conflict counsel like us to go through and would the commission like to do?
Starting as respondents fail to appear, we've asked for a sworn offer. And then we've also sworn our witness to give a summary of the evidence that we did. And I think that interpreted.
All right, acceptable to the commission?
What was the comment?
The comment was that we would have a sworn in-person proffer, both by counsel as well as by the witness after he is sworn.
Okay.
We don't need to swear in counsel, but
No, after he is sworn.
Yeah, a proffer is usually the attorney or attorneys, if there are more than one.
Right,
Essentially,
Mr. Goldbach, but what we're doing is the counsel will provide the proffer, but we're also going to have sworn testimony
Okay.
from the witness.
But a proffer is usually a statement by the attorney as to what her evidence would be if she called witnesses, but usually a proffer does not require that witnesses be called.
Thank you. We're going to go with both steps on this particular
Okay.
one, or these three, actually.
Get to see, okay.
For each, the complainant will have a chance to make the opening statement. And then after questions by the commission, any closing statement that you may wish and what your prayer for relief is. And then after we make the finding, Commissioner Solbach, we will have a separate determination, assuming that we did make a finding, of what the penalty would be. So 2 different stages for each one. Good. Thank you. All right, well, let's begin with George Briggs, complaint 761.
Alrighty, thank you, Commissioner. As I mentioned, I'll keep this as brief as possible, but I am cognizant that there are some friendly new faces in the room, so I will try to succinctly address the matter. So Mr. Briggs, as I mentioned already, was a candidate for governor in the 2022 election cycle, was required to file campaign finance.
Let me interject, I apologize. We had a pre-hearing conference on each of these to try to kind of simplify what the issues are, and these are alleged failure to file cases.
Absolutely.
That's the kind of the extent of them, and the parties were notified about the availability to come and testify. So this proffer is being made with the respondent's knowledge that it could happen.
Yes.
So please continue.
Yes, absolutely. And this is a simple failure to file the required campaign finance disclosure, receipts and expenditure reports. This would constitute 2 violations by Mr. Briggs: failure to file both the October 2022 receipts and expenditures report and failure to file the January 2023 receipts and expenditures report. As we've already discussed, the filing of reports is critical, and I will not repeat this policy aspect every time, but it's critical to ensure public access to information and transparency. And our agency is the only administrative agency in the state tasked with ensuring that these reports are filed and publicly available. I will be offering the executive director's evidence through a proffer, and then we'll swear him in when appropriate, and I will keep my presentation as brief as I can. As far as the evidence at issue here, we've already addressed jurisdiction, but in addition to that, service was proper as it was reflected in the proposed report and order. Service was made to Mr. Briggs at his home address, which was listed on the candidate's declaration of intention filing form. He signed for, as I mentioned in the proposed report and order, he actually signed for the original complaint and signed for the failure to files, indicating he knew he was required to file. And then the notice of hearing was not signed for, but as I had mentioned at the pre-hearing conference, we know that is where he lived. The first class mail was never returned. And Mr. Briggs, based on notations made by the Postal Service's tracking, appears to be telling the Postal Service he does not live there. And he, according to all the property records and the official forms, he does live there. So he has been properly served and notified. And there are specific legal obligations that he, as a candidate who served as his own treasurer, is required to fulfill. Candidates are required by law to file receipts and expenditures reports at various times in a cycle, including 8 days before a general election, the October 2022 report. And in addition to that report, which is required by 254148 A2, candidates are also required to file reports January 10th of the year after an election under 254148A3. Neither of these reports were filed. The commission staff is obligated to send via certified mail notice to any person failing to file those reports. Commission staff did that, and Mr. Briggs signed for the mail. He has also spoken with the executive director regarding his outstanding obligations to file since his receipt of the original complaint. And although all of efforts that we could possibly make have been made for compliance, it has not happened yet. As was mentioned by Commissioner Berger, the burden of proof for affirmative findings of fact is clear and convincing, which is not necessarily more evidence than preponderance, but is a testament to the quality of the evidence presented. And here, this is a cut and dry. He was required to file. He did not file. Staff provided him with notice of failure to file. In each instance, he still has not filed the outstanding reports. At this time, if Paige is ready and the executive director is ready, I would like to swear the complainant in for his testimony regarding the outstanding reports.
You do solemnly swear, sincerely and truly declare and affirm that the testimony you shall give in the matter at issue shall be the truth, the whole truth, and nothing but the truth, and this you do under the pains and penalties of perjury.
Yes, I do.
We're going to walk through the allegations of the complaint to ensure that the same is true today. Do you understand?
Yes.
Can you walk through as briefly as you can the allegations of the complaint?
Can be very succinct. Mr. Briggs was a candidate for governor. He was required as a candidate to file an October 2022 report and a January 2023 report. He did neither. Those reports are still outstanding as of this morning, according to my conversations with state campaign finance staff.
I don't have any more questions for this witness unless commissioners do.
I'll open it up to the commissioners.
I have one question. I looked online and found that he didn't file these reports, but he also didn't file a report in July, which in my mind would be harming the public because he went to an election without having filed that report. So why wasn't the July report part of this, a separate account for that?
I believe Mr. Briggs has been previously fined. I don't recall if it was for the July report or not. But I know that he has been fined previously for failing to file a report. There was only one report prior to this, so I assume it was the July report, but I don't recall immediately for sure.
It just seemed there was more harm to the public from that one missing than the other two missing because he lost badly.
Yes, so I think that obviously the statute requires filing of these reports.
Yeah, I get.
And they're still outstanding. Yes.
Any other questions? Okay. Commissioner Paul. Any other questions from any other commissioner?
Okay.
Would you like to close on this, on Mr. Briggs?
Yes, absolutely. And if the witness is, I can't remember the right word. Released is not the right word, is it?
That's not releasing because it'll be back in.
Absolutely. That's a good point. Additionally, in response to Commissioner Glenn's question, that was the civil fine that was assessed against Mr. Briggs in complaint number 739, which is mentioned in the findings and conclusions. He was assessed a fine of $5,000 with a reduction of $1,000 if the fine was paid within 30 days. It was never paid. Furthermore, Mr. Briggs has accumulated $2,300 in civil penalties, also basically late fees for failure to file these reports, and that has not served as a deterrent either. This is a clear-cut case of failing to file reports that are required, and because he was not deterred with the $5,000 fine imposed regarding the non-filing of complaint 739, these constitute the second instances of violations under the Campaign Finance Act. So the executive director requests the commission find George Briggs in violation of the Campaign Finance Act for failure to file the October 2022 and January 2023 reports and impose a fine amount of $10,000 with a reduction in the fine amount if Mr. Briggs files all outstanding reports within 30 days of the order becoming effective. For context, this is not the maximum fine, as those two counts constitute the second set of violations. So the maximum fine would be $10,000 per count for a total of $20,000. We are only requesting $5,000 per count for a total of $10,000.
Anything else you'd like to add?
And what's the reduction if you paid with him?
The reduction is up to the commission's discretion.
Okay, that's what I did.
As is the amount.
Mhm.
So the initial inquiry or decision will be made as to whether or not there's a violation.
Yes.
And I don't know if it's simpler to do each case at the same time, or if we want to break into deliberations on all three one time.
I think it'd be appropriate to deliberate after each segment.
After each one?
Yeah.
Right.
Oh, it's really been.
Okay, okay. Deliberations can be in a closed session, so if someone wants to have a closed deliberation, please make a motion. Otherwise, feel free to deliberate in public.
Now, we have always, I mean, we used to deliberate in closed session, but then we stopped doing that. Are we back to going into closed session again?
Well, apparently not, since no one wants to do that.
Uh-huh. But we could if someone wanted to.
Yes, we can.
Okay, all right.
Exactly.
I don't want to.
So it's open for deliberation and
Oh, I guess I would move also that the commission adopt the proposed findings and conclusions that the executive director had submitted.
or any revisions there too. Don't have to accept them as a law.
Are you looking for a motion, Mr. Hearing Officer?
I am at the mercy of this commission.
Well, I'll move that we find him, that we find that he has had that he's committed a violation. Two violations, I guess.
Second.
And before you second,
No.
to adopt the proposed findings and conclusions.
Yes.
This is a
Yeah,
fine
except for the
ball. This should make clear that he's being found responsible in this alter.
Right, I believe the proposed findings are set up as a default.
Is that-
They're set up as either or. On request.
Yeah,
Meant to this.
so as I
He
think,
just needs to amend the motion.
yeah.
Does that make sense, Mr. Hearing Officer?
Mr. Commissioner, I would say that it is, if your motion is to make the finding of liability with regard to the two events in the petition or complaint, to adopt those findings of fact as a default setting.
That's exactly what my motion was.
I second it.
Okay.
Any further discussion on it or alteration? Hearing none, all in favor of the motion, please signal by saying aye.
Aye.
Anyone opposed? Anyone opposed, please say nay. The ayes carry. Now we have the secondary issue with regard to the amount of the penalty.
Mr. Chairman, I'd move that we impose a fine of $10,000 as requested, $5,000 per account, with the understanding that if it's paid within 30 days and
It's filed.
he files within 30 days, that it'll be reduced to 2,000.
So the motion is for a total of 10,000. If fully filed within 30 days, reduced to 2,000.
If it's paid within that 30 days, yes.
To clarify, is the motion for all outstanding reports to be filed?
That's correct.
Okay.
I'll second it.
Any other discussion with regard to the motion? Hearing none, all in favor, please signal by saying aye.
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 Those opposed by saying nay. Nay. I believe it passes. Okay, did our numbers add up? Okay. Thank you. The next.
Last thing to do is,
Oh, okay. Yes. So, our conflict counsel is advising that we need a motion next to authorize me as the presiding officer to sign this as a proposed findings or draft an ordinance.
render, to draft and sign an order reflecting the deliberations and determinations of the commission.
I thought they were adopting my proposed order, though. We wouldn't be drafting a new order, right?
What will still be a document for that.
Yeah,
Oh, sorry.
it will largely reflect the proposed order as they discuss.
Okay. I was so amused. Having been in the chair first time around, I was very well.
So we have a motion authorizing me as just the presiding officer to draft up the order commemorating our activities.
Reflecting,
Like, I would say, yeah,
reflecting the record.
Like the record, I appreciate that. On the bench. Do we hear a second? Second from Mr. Solomon. Any other discussion? Hearing none, all in favor, signal by saying aye.
Aye.
All opposed,
Aye.
nay? Oh, sorry. All opposed, nay? And we need to do a, whether or not we want this referred to the AG's office or the DA.
yes, that is the last stage. So your finding will be sent to the Attorney General's office. The commission can also propose to make a recommendation regarding the prosecution.
Okay. If you didn't hear him, we can make a recommendation to have this as a matter for prosecution.
The motion did not include that, so we make no recommendation. We just pass it on as required by statute.
If there is no motion made to separately make that, then we'll let it die. So people are still free to make that recommendation. I think that.
But we do have to pass it on to the to the prosecuting authorities, and it's up to them whether or not to prosecute.
Right on. Hearing no motion, it dies. Anything else for that?
That should complete that.
Fine. I will declare that hearing closed at this point in time, and with my initial leading with the others, I'd like to open complaint 766, Sam Stillwell. And would so since we have begun, no new individuals have entered this room. Dave, would you take another look outside? I will have one stop.
No,
Thank you. So no one else is in the hallway.
correct.
Thank you. I will hand it to Dave for an opening from council.
Thank you. Again, this is another cut and dry matter. Sam Stillwell was a candidate for state representative in the 2022 election cycle, who was required to file reports and didn't do so. His two violations are for failure to file an amended July 2022 report and failure to file a January 2023 receipts and expenditures report. I don't want to reiterate the policy again and again, but as we know, it's our agency's job to ensure transparency. I will be offering evidence as a proffer and swearing the executive director in when appropriate. Jurisdiction has already been discussed. Again, Sam Stillwell was a candidate subject to our subject matter jurisdiction and lives in Kansas. Daniel Stillwell served as Sam Stillwell's treasurer. However, under KSA 254152, both the treasurer and the candidate who is appointed such treasurer are responsible for reports that are not filed by the deadline.
We're talking about Sam, right?
We're talking about Sam, yes. I will not be using Mr. Stillwell at all because I feel like that is too confusing with two of them. So Sam Stillwell was properly served as well as also reflected in the proposed report and order at his home address, as was listed on the candidate's declaration of intention filing form. He actually signed everything, signed for the complaint, all the failures to file, and the notice of hearing, which also included notice of the pre-hearing conference. The only difference in law in this hearing, as opposed to some of the others we will address, the other that we addressed, is that 254148F provides that the commission may require a treasurer to file an amended report if the original report contains errors and omissions. And again, because of 4152, the candidate is also responsible if that amended report is not filed. The original July 2022 report for the Stillwell campaign contained material errors and omissions because no one signed the report. Sam Stillwell did not sign it, nor did he attach the required Schedule C. And so he was sent an error and omission notice, was told of the changes that he needed to make explicitly, and did not file that report. Additionally, candidates are also required by law to file reports on January 10th of the year after an election year, that January 23 report, and that was not filed. Commission staff again complied with 254152 and sent via certified mail notice of the failure to file the reports and notified Sam Stillwell of his obligation. I will also note, as was identified in the administrative record, that would be incorporated by reference in the proposed report and order, that Karina Renna, the state campaign finance coordinator for the commission, has also spoken with Sam Stillwell on the phone and discussed his outstanding obligations to file after the complaint was filed, and still nothing has come of that. Clear and convincing, again, is the evidence that is the standard that is applicable and is about the quality of evidence being higher than that required of preponderance. As I mentioned, staff provided appropriate notice for all the failure to files, and no compliance has occurred, unfortunately. Now I would like to swear the complainant in for his testimony regarding the outstanding report with the presiding member's permission.
I believe you are still under oath.
Oh, that is correct. Okay.
Proceed.
So first, you didn't do this before. Would you please introduce yourself?
Mark Skoglund, Executive Director of the Kansas Governmental Ethics Commission and complainant in these three matters.
And let's walk through the complaint allegations again. Could you please provide a summary and current status?
Yes, Mr. Stillwell, Sam Stillwell, was a candidate who was obligated to file reports under this act. He, as occurs for many candidates, he had made errors in his receipts and expenditures report. He was sent an error and omission notice for his July 2022 report, which required an amendment be filed. Additionally, he was required to file a January 2023 report. Neither of those reports were on file as of this morning, according to a conversation I had with our state campaign finance coordinator.
I don't have any more questions for the witness unless commissioners.
Any commissioners have any questions?
In those phone calls, did they discuss that failure to file Schedule C at all?
I don't recall exactly. I think he said that he knew and he understood and just needed to be sent the forms again based on the memory of the
I
conversation.
mean, I looked at that report and he didn't report $358 of expenditure. So we're getting into very serious fines for failure to file $358
Well, the issue,
Schedule C.
yes, respectfully, the issue, I guess, is that of compliance of what is necessary to comply, because the public still has a right to access information. We wouldn't know if he's not disclosing that in his reports. And again, it's up to the commission's discretion on what the appropriate fine amount would be.
But he filed an okay in October, but then he didn't file. You're finding him before and after the October report that was okay. So
Yeah,
it seems
yeah.
odd.
No, I see what you're saying. Sorry, I don't know if that was responsive to your
Yeah,
question.
that's
Okay.
Any other question? Anyone else have any questions? Hearing none, would you like to close?
Absolutely. And as a few final points, Sam Stillwell also has accumulated a large amount in civil penalties, $2,560 for failure to file reports. The amount has not encouraged compliance whatsoever. This is another instance of failure to file the requisite reports with a clear obligation to do so. In this instance, although there are two violations, the executive director makes a few asks of the commission. The first prayer for relief that we would ask is that the commission find Sam Stillwell liable under the Campaign Finance Act for failure to file an amended July 2022 report and failure to file a January of 2023 report. The next ask is that we request the commission adopt the proposed report and order submitted and find that Sam Stillwell is in default for lack of appearance at both the pre-hearing conference and the hearing today. And the final request the executive director makes is that a fine amount of $5,000 be imposed upon Sam Stillwell, with a reduction of the fine amount if Sam Stillwell files all outstanding reports within 30 days of the order's effective date. And pays the reduced amount. For context, this is again not the maximum fine, as the 2 counts in complaint 766 constitute 2 violations under the Campaign Finance Act. Therefore, the maximum amount that could be awarded is $5,000 per count, and we are only asking for $5,000 for the fine. Further, if the commission chooses to offer a reduced fine in exchange for payment, I just said the same thing twice. Apologies.
I didn't hear you.
Scratch that, redact that. So those are all of our prayers for relief. And with that, I am full.
Thank you. Thank you. Do we have any? Well, I'll ask again, does anyone wish to deliberate in private as we are authorized to do? If so, make a motion, otherwise we'll continue in public. Please deliberate.
Hearing officer, if you're prepared, I'm prepared to make a motion.
Yes, please.
I would move that the commission find that the commission has subject matter and personal jurisdiction over Sam Stillwell in complaint number 766, and that the proposed findings that fall for counsel for the commission and the testimony of the executive director, Mr. Scogan, support the findings and requests as set forth in the record, and we adopt those findings and find that Mr. Stillwell is liable for failure to file the reports in July of 2022 and 2023, and all of the proposed findings that has been recommended by council, and find that Mr. Stillwell is in default to be.
So you're a good one for you to second.
Do I hear a second?
Second.
Moved and seconded. Any discussion on the matter? Hearing no discussion, all in favor, please indicate by stating aye.
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 Anyone opposed by designating nay? So we have found that he is liable, that's in default, is liable. Now we need to move to the question of the amount.
And I'm prepared to make a motion.
Please do.
I would move that the assessor fine of $5,000. I do not, my motion is to post a fine of $5,000 for the violations stated in the record of public language.
So the motion is for a $5,000 fine / penalty. Do I hear a second?
It's only fine. We can't complain.
Oh,
Civil
sorry.
penalties are.
Oh, thank you very much. Fine, just a fine, not a penalty, just a fine.
Are you proposing any deduction if he files everything and pays a reduced amount?
Based upon the record, I'm not sure.
Okay. I'll second the motion.
Moved and seconded. Any further discussion? Hearing no discussion, all in favor, please designate by saying aye.
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 Anyone opposed by saying nay?
Nay.
I believe that it passes. And Ms. Ramirez, did you vote?
Aye.
Aye. Thank you. I believe the next step is to authorize myself in this particular instance to prepare an order that outlines our deliberations and these proceedings. Do I hear such a motion?
Mr. Hearing Officer, I would move that you be authorized to counsel prepare the journal entry in this matter reflecting the evidence presented and findings made by the body.
So moved. I hear a second.
Second.
Any discussion? Hearing none, all in favor, please designate by saying aye.
Aye.
Opposed by? Okay, no nays. It is. And I know it's not part of the motion to refer this to prosecution, but if anyone wishes to refer this for prosecution, please make that motion.
It'll be referred automatically.
Well, it is sent, I believe it is sent to the agency.
If they recommend.
Recommend. Oh, I'm sorry, thank you.
We don't have to make a recommendation. It would be up to the prosecutor to.
Correct, correct. But if someone wishes to make the recommendation for prosecution, then this will be the time to do so.
Find the set effects and it cost me being there, but otherwise I prefer many lives beside that. Instead of driving.
By hearing none, it would die for lack of a motion. I will declare this hearing closed. And now return to our third of our introductory kind of sex complaint number 767, Daniel Stillwell. Would you like to make your oath?
Again, something called the check.
Thank you very much, sir. No one has entered the room since we've begun, and Paige is checking in the hallway. And no one knew was present there.
Can I proceed?
Please do.
So this is, Daniel Stillwell is the treasurer for Sam Stillwell, candidate for state representative in the 2022 cycle. Daniel Stillwell is equally liable for the obligation to file campaign finance reports, and he did not do so. This is, again, 2 instances of Campaign Finance Act violations: failure to file an amended July 2022 receipts and expenditure report, and failure to file a January 2023 report. Again, transparency is our goal, and I'll be offering once again the evidence through a proffer and swearing the executive director in as appropriate. Daniel Stillwell, as a treasurer, was subject again to the commission's subject matter jurisdiction under the Campaign Finance Act and is a Kansas resident. Service was properly made. Daniel Stillwell, again, also signed everything he received, or the original complaint, the notice of hearing, all the failure to file notices, and was served at his home address as listed on the candidate's declaration of intention filing form. We were also told by Sam Stillwell that Daniel Stillwell was his son, so there is confirmation that it is the same correct address. Regarding legal obligations to file, again, 4148F allows the commission to require a treasurer to amend if there are material errors or omissions in a report. The July 2022 report for the Stillwell campaign contained errors and omissions because the report was not signed, nor did the campaign attach the required Schedule C to the report. And the other legal obligation was for the January 10th report, which is pursuant to KSA 254148. It's January 10th, the year after an election, a report must be filed. And KSA 254152 requires the commission to send notice to any person failing to file a report required by the act and notifying them of their obligation to file, and our staff met this requirement. I will note, just to be clear, on the phone call with Sam Stillwell, Daniel Stillwell was not also on the phone. So to be clear, we only, Karina Renna, the state campaign finance coordinator, only spoke with the candidate, Sam Stillwell. The burden of proof is the same, a clear and convincing standard for affirmative findings of fact made by the commission. For as far as the evidence regarding Daniel Stillwell's obligation to file, again, it is a very clear, arguably just a question of law. He was required to file. There was no termination of the campaign, and the reports were not filed, neither the amended July nor the January 2023 report. At this time, I would like to continue with the work that our witness has done before he may finally rest. So would you start by introducing yourself once again, please?
Our witness will remain sworn.
Mark Skoglund, Executive Director of the Kansas Governmental Ethics Commission, complainant in this matter.
And again, could you please provide us an update, if there is any, and a summary of complaint number 767?
I have no update. With permission of the hearing officer, I would re-allege my testimony from the hearing on 766 for Mr. Sam Stillwell, as the same would apply.
To clarify that, we have 766 and 767, that's the exact same facts
that are involved in each,
That is correct.
with the exception of who each officer or each individual.
Yes.
So there's no distinction between the responsibility of either party.
That is correct. Both the chair and treasurer are legally obligated, or both the-
Candidate.
I apologize, both the candidate and treasurer are legally obligated to file their reports, and they're held responsible under the Campaign Finance Act.
I don't have any additional questions for my witness.
Thank you. Any questions from commissioners? Not hearing none. Why don't you close?
All right, may my witness rest. I would like to let him rest. And Daniel Stillwell has accumulated a total of $1,370 in civil penalties. The penalties are lower for treasurers as opposed to
Sorry, can you state the amount?
$1,370. Sorry. And civil penalties, the amount, again, has not encouraged compliance. This is, again, a clear instance of a requirement of a treasurer for a campaign to file that has not done so. Again, in this instance, the executive director makes the same prayers for relief from the commission that the commission find Daniel Stillwell in default for, receiving service that was regular and proper and not attending either the pre-hearing conference nor attending today's hearing, that the commission adopt the executive director's proposed report and order, and that the commission find Daniel Stillwell liable under the Campaign Finance Act for failure to file an amended July 2022 report and failure to file a January 2023 report. The final ask we would make of the commission is we would request a fine amount of $5,000 be imposed upon Daniel Stillwell with a reduction in the fine amount if Daniel Stillwell files all outstanding reports within 30 days of the order's effective date and pays the lower imposed amount. For context, again, this is not the maximum, as there are 2 counts in the complaint that would constitute 2 violations under the act. Therefore, the maximum fine would be $10,000 total. And to be clear, in this instance, if either Sam Stillwell or Daniel Stillwell files the outstanding reports, so long as the reports for the campaign are filed, that would satisfy the former aspect of our request.
On a clarification,
Absolutely.
the payment of $1,370 in addition to any other amount determined and voted by the commission. He has outstanding payments of $1,370.
He does. That was not part of our original request.
And that's
Which-
within the discretion of the commission.
Yes, absolutely. Okay, I have concluded.
If anyone wishes to hold these deliberations in private, as we are authorized to do, please designate that. Otherwise, please begin deliberation. With motion if you wish.
I'm fine to deliberate in public.
Or else with permission, I'll make the motion.
Yes, please.
Do you speak up for Paige?
Sorry, Paige, I do speak softly no matter what.
It's okay.
I would move that the commission find that commission has subject matter and person jurisdiction over Daniel Stillwell, that all appropriate notices have been provided to Mr. Stillwell, that he has failed to appear at either the pre-hearing or today's hearing, and therefore we should find that he is in default in this matter. That the commission further find that the offer of the council and the executive director support the factual circumstance of failure to file in this matter, both the amended July 2022 and the July 2023 required report. And under those factual settings, that we find that there is a violation in case number and complaint number 767 on behalf of Mr. Stillwell.
Do I hear a second?
I will second the motion.
Oh, I think Mr. Stillwell got you first. And any discussion? Hearing no discussion, all in favor, please indicate by saying aye.
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 Opposed? Opposed by saying nay. All right, hearing none.
Oh, Andrew, good.
Oh. Andrew's a nay. Thank you. It passes. We now move into the the fine stage of things to hear any motions for discussion.
Very also again, I would move that based upon the findings supporting the allegations of complaint number 767 and the behaviors outlined in that particular complaint and findings made by the commission, that we impose a fine of $5,000. The previous amounts of 1370, of course, remain unpaid. But that would be an obvious statement that in addition to fine, he also required to pay the outstanding balance of 1370. I do not make any requirements of any reduction in this sum, which is prevented.
So the motion is for 5,000 and which would be in addition to the $1,370 that's otherwise owed. He's open to a second if someone wants to have a reduction.
Yes, second. Also,
All right, seconded without reduction by Mr. Solbach.
second, the motion is made.
Thank you. Any discussion? Hearing no discussion, all in favor indicate by stating aye.
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 Opposed by stating nay.
Nay.
And
One nay.
2 nays.
Oh, two nays. Andrew?
on my previous vote, it was supposed to be an aye. I got confused what we were voting about.
Your eye for the findings, but an A for the finding. Okay.
Okay. He still pass, even with that alteration. I would ask for authorization for myself as presiding officer to draft, review, and sign an order reflecting the findings and conclusions of the commission as a whole.
And I would move that the hearing officer be authorized to draft, review, and sign an appropriate journal entry reflecting the findings of the commission in this matter and consistent with the presentation of testimony that is on the record at this time.
Second.
Moved and seconded. Any further discussion? Hearing none, all in favor indicate by stating aye.
Aye.
Opposed? Opposed, nay. Andrew, I'm looking at you.
Not this time.
Thank you. And if anyone wishes to recommend prosecution of this matter, then this would be the appropriate time to make that motion. Otherwise, it will die for the lack of motion. And it dies. I will close this hearing. This concludes the 3 hearings that we have had. I also, I turn this matter back over to our chairman with my gratitude for being the presiding officer.
Thank you, Commissioner Berger. We really appreciate you taking the helm to lead us through these hearings. And just for other commissioners to know, the idea at this stage is to allow other commissioners the opportunity to conduct hearings in the future. I think it is for everyone to decide to some extent the format that they want to operate under, conditioned upon the law, of course, and the Administrative Procedures Act and our obligations. So, to that end as well, Caitlin and Director Skoglund, the commissioners appreciate any advice on how future hearings need to be conducted, but I thought Commissioner Berger did a great job, and I think that we can emulate this mode going forward.
I will note that we have reached out to the Office of Administrative Hearings just for ideas on streamlining default judgment hearings. But I think that this went very well. We actually knocked out 3 hearings in, I think, under an hour, I think in 45 minutes, which is remarkably faster than our first go rounds on now that we're subject to CAPA. So I think we're learning, and I think it's getting better every time. So this was great.
And just as a lesson learned, I did, even though it wasn't too meaningful here, the pre-hearing meeting really can be a way to accelerate at least the presiding officer's understanding of what's going on and address some issues up front so that we can accelerate.
I'd also like to thank Jay and Jesse for their input as council council in this matter. That's been very helpful in that regard.
Well, great. Well, thank you again. Moving back to the agenda, we have the remaining item of a recessed session. And Director Skoglund, do you have a sense of how much time we need to reserve?
You have a fair bit to talk about there. So I think you all have seen the materials. It's however long you think you'll need. I think it's gonna be a while though.
Two or three. I need to give us a time.
And I just, said that Jesse has said that he needs to leave a little before 3.
And then
About 3.
time.
So
I would-
Let's say
I would say 30 so
We
that
started
Paige
off
has
with
time
30.
to put the stuff out.
Yeah.
I did that Jesse in the first time.
So go until 3, you think?
Yeah, I would say 30, beginning at 2:30 and leaving at 3.
And then if more time, more discussion is
Yeah.
needed, you can obviously go back in, but that's a good natural break for
Yeah.
Jesse to leave if he needs to.
So do we want to take a break now for 5 minutes and then plan to begin closer to 2:30?
Technically, it's a recess session either way, so. if you-
Yeah, because you could close, I suggested giving that extra 5 minutes so that Paige has time to give the paperwork out.
So if you just
Okay.
recess until 3, then
Okay,
you can take a break for 2 or 3 minutes first, I think. I mean,
okay.
yeah, Jay agrees.
Do any,
So-
do any commissioners have the motion handy that they care to read off the motion that would bring us to 3 o'clock? In the past, we've had a commissioner be our go-to for reading all of the recess and executive session motions, and I would appreciate anyone that wants to volunteer to take that position.
2 p.m.
I have.
Three. I could do it.
Oh, good.
I moved that the commission recess this open meeting with conflict counsel Jay Rodriguez and Jesse Burris present to discuss matters related to confidential investigations pursuant to KSA 254165 and KSA 254161, and for good cause as provided by KAR 119-6-2. Justification for recess is so the commission can exercise quasi judicial functions when deliberating matters related to said confidential investigations as contemplated by KSA 754318-8G1. The open meeting shall be resumed here at 3 p.m.
Second.
Motion has been seconded. Any additional discussion? Hearing none, all in favor of approving the motion signify by saying aye.
Aye.
All opposed say nay. The motion passes.
I am
Let us know
stopping-
when you're ready.
Oh, I leave your name out then.
Yeah,
Yeah.
Okay, reading.
good call. Thank you. Oh, I have that same pad folio.
Okay,
Sounds good.
this says it's live. Yep, we are
Okay.
live again.
All right, Commissioner Glenn, if you could do us the honors.
I move that the commission recess this open meeting with conflict counsel Jay Rodriguez present to discuss matters related to confidential investigations pursuant to KSA 254165 and KSA 254161, and for good cause as provided by KAR 1962. Justification for recess is so the commission can exercise quasi judicial functions when deliberating matters relating to said confidential investigations as contemplated by KSA 754318G1. The open meeting shall be resumed here at 3:15 p.m.
Second.
Motion has been seconded. Any additional discussion? All in favor of approving the motion to adjourn to recess session signify by saying aye.
Need to add that I forgot to say before I left. That is open meeting appropriate,
Okay,
if that's okay. And it relates to, okay, are we back?
I think we need to say something.
Yes, you may have already known, but I forgot to make an announcement.
Did you give me this? No. Oh, yeah. Well, that was
Okay, we are back.
okay.
Commissioner,
Yeah,
So
we
with
are back to open session. Caitlin, do you have a statement you wish to make?
yeah, I believe, I'm not sure whether or not this was addressed in the closed session, but regarding complaint number 771, I meant to request a continuance for probable cause until the June meeting because the respondent in that instance, the address has changed.
Okay,
Okay,
We're on board.
noted.
thank you, Jay. Anyway,
Uh,
okay.
Commissioner Solbach,
Mr. Chairman, I would move that we find sufficiency in complaint number 780.
do I have a second?
Second.
Any additional discussion on the motion to find sufficiency in complaint 780? All in favor of approving the motion signify by saying aye.
Aye.
All opposed, say
Mr.
nay. The motion passes.
Mr. Chairman, I would move that we find sufficiency in complaint number 781. I understand we have one person who's going to recuse himself.
Sure. Do I have a second?
Second.
Motion has been seconded. All in favor of approving the motion signify by saying aye.
Oh, hold on. Just make it
All
clear,
opposed,
Mr.
say nay.
Wait, Mr. Harrison is who's recused.
I recuse myself from consideration in regards to complaint 781.
Very good, I will.
Thank you. Noted, Mr. Commissioner Harrison. Commissioner Solbach, any additional motions?
I would move that we grant the request for additional time in complaints number 750, 753, and 754.
Was, just as a procedural, was there actually a vote on 781's sufficiency?
Yes.
Okay,
Yes.
sorry.
I'm high for it.
Okay, sorry.
And also, go ahead.
Well, the motion as you've worded it is to grant an extension in complaints 750, 753, and 754. If there's no other qualification, do I have a second?
We need-
The request was made by the chief. Responding party. Just for clarification.
To the June meeting.
Right.
To the June meeting.
Yeah. Yes.
Do I have a second?
Second.
Any additional discussion? Hearing none, all in favor of approving the motion to continue complaints 750, 753, and 754 until the June meeting, signify by saying aye.
Aye.
All opposed, say nay. The motion passes.
I would move that we continue complaint number 771.
Until the June meeting.
June, yes.
Yes,
Meeting, yeah.
Mr. Chairman.
Second.
Okay. Motion has been seconded. All in favor of approving the motion to continue complaint 771 until the June meeting, signify by saying aye.
Aye.
All opposed, say nay. The motion passes.
Mr. Chairman, I would move that we dismiss complaints 778 and 779.
Do I
Second.
have a second? Motion has been seconded. Any additional discussion? All in favor of approving the motion to dismiss complaints 778 and 779, signify by saying aye. All opposed, say nay. The motion passes.
Mr. Chairman, I move that we find probable cause in complaint number 774. I make that separately so that one of our commissioners can recuse himself.
Do I have a second? Motion seconded. Any additional discussion? All in favor of,
Aye.
all in
Yes.
favor of approving the motion to find probable
Mr.
cause?
Chairman,
Mr. Harrison needs to recuse.
Mr.
Noted.
Chairman, I hereby recuse myself in consideration in regards to complaint 774.
That'll
Noted,
assume.
Commissioner Harrison. For all other commissioners, if you approve of the motion, signify by saying aye.
Aye.
All opposed, say nay. The motion passes.
Thank you, Mr. Chair.
Mr. Chairman, I would move we find probable cause in complaints 769, 770, 772, 773, 775, and 777.
Is the motion
Second.
seconded? Motion has been seconded. Any additional discussion? Hearing none, all in favor of approving the motion to find probable cause with respect to the complaints that Commissioner Sobak just listed, signify by saying aye.
Aye.
All opposed, say nay. The motion passes. I believe this concludes the motions.
I need to ask, complaint number 760 remains with no action. We will run into legal issues if we continue to not act on a complaint that is sitting there for probable cause. Can the commission provide some guidance to parties about what is causing the decision to continue to not make a finding one way or the other on probable cause? We have no information.
Is that the case? It's in litigation right now?
We
There,
can't speak to that in open session.
Well, that's the whole dilemma.
Can the commission
Well-
provide us, sorry,
That's the whole dilemma. There
Well,
are things
I
we
would-
need to know that because of the separation, we can't discuss with one of the parties.
can a statement be made to the parties about what the delay is and what the parties can do to help resolve the delay?
I would invite you to discuss that with a conflict counsel.
Yeah. I mean, the same.
He's in the same boat.
Same conflict.
The answer is no, we can't.
I mean, maybe what we need to do is have you maybe brief it to us on your opinion on what we can share or how we should,
That's a general matter.
as a general matter, not on a particular matter.
Yeah.
But what happened?
I respectfully, there have been pleadings submitted that have requested the commission to act and provide a justification for why the commission's action is appropriate.
Correct. You
We,
know what?
we respect that.
I'm trying to see what you're asking for, rather.
I'm asking not as to a particular matter, but generally speaking, how the
How we now,
issues concerning our deliberations in our recess session can be brought to the party's attention in any respect.
Is it possible to have a recess session that is attended by the parties on the matter as a quasi judicial function?
Defer to council.
That's, yeah, I apologize. I'm directing that question to Jay.
The justification for recess session is to deliberate on quasi judicial matters. Doesn't seem like it would be appropriate for me to participate in deliberations. I think what Commissioner Berger has requested is possibly a general discussion about how the commission can handle issues where the commission needs to discuss with the parties aspects of the complaint prior to finding probable cause.
I think I know what we need, maybe.
And
We'll find out.
I don't think it requires a motion from the commission either. So if you'd like to present to the commission, they may benefit from your opinion on that issue as it might recur.
As what we think the issue might be.
No, not issues, but the procedure.
Okay.
I don't want you to address issues.
Right.
Keeping this as general as I can, is this kind of a sphere of influence question based on what? I can't, I'm just gonna stop.
We are unfortunately in a situation of unintended consequences where they have roadblocks on both sides of the road.
I think there may also be unintended consequences to continuing down this path though as well, which I know you're aware of.
Disagree
I'm
with
just
that at
making
all.
that point.
I don't disagree with that at all.
Okay,
I don't know what path.
The
Well-
path of not choosing probable, to not making a determination of probable cause.
Well, we're given two choices by statute.
Correct.
But there are third alternatives, which is where we're getting hung up.
I don't
know what that would be.
You can't be concerned with the unintended consequences on the other side.
Are these issues that can be resolved in a post probable cause hearing where we can appoint a hearing officer at that stage? Because after probable cause is found, a hearing officer can be appointed and a lot of issues get resolved. We can have these hearings, we can have pre-hearing conferences, we can have status matters, parties can attend.
Well,
Again, it might be useful to present that argument in more detail.
I think we did. I think that was part of what we briefed.
The question though is, rather than the specificity of applying to the matter at bar, you want a general guidance on how we deal. I think I understand what you all want.
We appreciate
So-
that. This is a good discussion.
Yeah.
Dovetailing to a different issue, but sort of the same issue. I think it'd be useful on sufficiency and probable cause, and you briefed that once before. And I know we've new people and I'm always forgetting how that all works, but sufficiency, probable cause, what are the standards for this commission as an administrative agency?
No, that's helpful. Thank you.
Yeah, and
Sorry, go ahead.
I'll just say that this kind of goes to some of these issues that come up kind of go back to the value of having a placeholder on the agenda of a general counsel's update. I think with each meeting, there's some new gradient that is revealed that the commission could use some additional guidance on, and I think this is one of those areas.
I would like to remind Chairman Hale that we do need to appoint hearing officers for
I think 9 different.
complaints. 7697, a lot.
And we have, yeah, so I guess just for the record, we'll note that we have tentatively set hearings and complaints 769, 770, 772, 773, 774, 775, and 777 at our next meeting, provided, however, we understand that there would be pre-hearing conferences, and of course, there's just the limitations of time. But with respect to hearing officers, Commissioner Helmer has agreed to serve as hearing officer in complaint 769. Excuse me.
I move that we appoint Vice Chair Helmer as the hearing officer, presiding officer for 769, 770, 772, and 773.
The general don't need a motion. It's just up to the chairman.
Just administrator.
Okay. So.
Okay.
That's within our.
Well, that's fine, but
So Commissioner Helmer will serve as hearing officer in complaints 769, 770, 772, and 773. And Commissioner Solbach will serve as hearing officer in complaints 774, 775, and 777. And we'll just expect that staff and the executive director will let the commission know, just based on availability and what we learn in the course of pre-hearing conferences, just what we can expect at our next meeting.
Great. Perfect. We can do that.
Okay, and then the only other item on the agenda was to simply note that we will meet in 5 weeks on June 26th. Do we have any other matters we need to discuss before we adjourn?
I think Jay may have been.
well, I was just gonna let the commissioners know when we serving as presiding officers that I will get in touch with you to work on hearing notices for the pre-conference hearing.
Okay, noted. Well, if there are no other items to discuss, I will take a motion to adjourn.
So moved.
Do I have a second?
Second. Thank you.
Motion that has been seconded. Any additional discussion? Hearing none, all in favor of approving the motion to adjourn signify by saying aye.
Aye.
All opposed say nay. The motion passes. This adjourns the May 22nd meeting of the Kansas Governmental Ethics Commission. Welcome again to our newest commissioners, and thank you everybody for participating today. It is greatly appreciated. So we will look forward to seeing everyone in 5 weeks.
Thank you all for 2.5 hours of
Thank you.
tough work. Really appreciate it.
Great.
Test
Thank you all.
the